Well, good morning. For the record, today is December 19th. This is the Senate Judiciary and Public Safety Committee. I want to welcome you all to this hearing. This hearing is trying to address a response to the violence that we see in our communities from one border to another. Those of us that have the nameplates in front of us are members of the Judiciary Committee, and it's common courtesy that any other senator that wishes to sit in on any other committee that they're not a member of, I was about to say they don't belong to, but that would be wrong. We give them the courtesy to sit in Senate chairs whenever they come in. We're not going to have I want to announce today, we're not going to have any bill hearings today. We're not taking testimony from the public. This meeting is to simply understand Minnesota's existing laws in how we respond in the past and currently with violence and crime in the state of Minnesota. I think there are some people in the past discussion that I've listened to kind of have an impression that Minnesota has no laws regarding violent crime, and that simply would not be true. But I think it's good to have to set a baseline for discussion later this coming session. Violence is in the news every day, and despite what's being heard outside this door, out in the foyer, this is not window dressing. And the bills that have been circulating more than likely will be heard this coming session. This is to start a discussion, but we have to start at a point where we understand Minnesota's current laws. As I said, violence is in the news every day, and it's typified even on low levels. A parent punches a coach at a football game. A student attacks a school employee at Armstrong High School, where I used to go. There are multiple accounts of increased crime in the Twin Cities light rail system. Gang activity is not limited to the metropolitan area, but we're seeing it surfacing all across the state in different communities. Just this year in St. Paul, the rate of homicides is at the highest in a decade. And to quote Police Chief Todd Axtell, their special investigation units are simply absolutely exhausted. And it does raise questions about whether law enforcement agencies in that particular area are being adequately resourced. I pulled together a large set of news articles. Members, you have them in your packets. It's this packet here, and this is just a sample of the news articles that have been circulating just in the last few months, typifying a rising crime and rising violent crime in our society. What we're trying to do is have a better discussion about the larger systemic problem that we are beginning to witness, and any legislation just can't focus on the type of weapon that's used or who is committing that crime. We have a problem in our culture that's beginning to surface, and I'm glad you're all here to help us. In seeking to understand this problem, I requested further information on crimes of violence from the Minnesota Sentencing Guidelines Commission. For those of you who aren't familiar with that commission, that's a commission that tracks the pattern of crime in Minnesota. It collects data, it quantifies it, it makes it easier for us to focus on that, and we have copies of that information as well. And for our members on Judiciary Committee, that too is in your packets. Today will be the beginning of 2 informational hearings on violence prevention, and it's meant to create a baseline of current laws so we understand how to react properly, and if there are existing laws that need to be repealed or amended, that's what we need to start at. We need to start at a baseline. I've instructed our nonpartisan staff, Mr. Backus, who's sitting at our testifying table, to give us a review of Minnesota law regarding this area of crime. This is more a considered, I'd say, a workshop on trying to understand what Minnesota has done in the past on how to address violent crime. It's mostly criminal law. And it'll start our discussion. I'm asking our members to hold questions until after Mr. Backus is done. It's really difficult to give Mr. Backus a direction on reviewing laws regarding this because we have so many laws in the state of Minnesota regarding criminal law. And so he has a lot of information to cover. We've tried to focus our attention on how we respond to crime prevention, and it may go in other areas as well. But nevertheless, we're going to have him start on it, review current law as it relates to violence in its entirety. If we did that in its total entirety, we would be here for a few days. We have about 2 hours, a little more than 2 hours here, so we're going to get going real soon. I think I have given the instructions to the committee to hold their questions until later. And my hope is that we have a chance to better understand where Minnesota is and where it might go if it needs to move at all. Again, I want to welcome the citizens here in the room. I wish every meeting we ever had would be filled with citizens watching what we do. I think we'd have a much better form of state government. As I said before, we're not going to be voting on any issue today. This is an information hearing. We have no bills before us, and that's intentional. But I do want to make mention that we will have our second meeting, and that will be next month, and we will hear existing proposals. There's quite a few of them regarding violence. Some are talking about police resourcing, and others are talking about guns and what do we do with that. And that'll be next month. But nevertheless, I'm going to open it up for Mr. Backus. Oh, one other thing. Sometimes these issues may trigger an emotional response, and we're asking, according to Senate rules, to avoid any clapping, cheering, sign waving, or any other outbursts of emotion. We're trying to have a meaningful discussion, and I hope we all can learn something from it today. Mr. Backus, would you identify yourself for the record?
Thank you, Mr. Chair, members. I'm Ken Backus. I'm the counsel for the committee. I handle the criminal area of the committee. So I'll start with a little bit of an overview. I've been asked by the chair to give an overview of certain areas of firearms laws. Specifically, I am going to give...
Mr. Backus, could you direct that microphone to be right in, directly in front of you and close?
Is this okay?
I think so.
First, I'll start with a brief overview of the current lay of the land regarding federal and state authority to regulate firearms, and then also have a brief overview of the Second Amendment and recent U.S. Supreme Court jurisprudence on that. Then I will look at ineligibility to possess firearms at both the state and the federal level, and I've been asked to give more detail in the area of mental illness, domestic violence, and criminal conviction-related ineligibility. Following that, we'll look at transfer requirements under both state and federal law, and also especially focus on background checks. And then finally, we'll look at crimes related to firearms in Minnesota, but mostly focusing on crimes related to transfers of firearms. Now, as the chair mentioned, I can't cover all aspects of firearms laws today, so we'll focus on just the areas that the chair asked that I look at. Now, this will be pretty detailed, it will be quite detailed, but however, it can't quite be as detailed as I'd like due to simply to time constraints. This is a really complicated area of laws. I think you all know there's federal and state overlap, there's constitutional issues and case law involved. And also, there's just going to be a lot of exceptions and exceptions to exceptions and caveats, and I'll do the best I can to drill down to that, but sometimes I'll just be talking about what the general rule is without getting into all the specific exemptions. Particularly, before I start, I want to acknowledge all the experts and the accumulated knowledge in the audience. I haven't seen everybody here, but generally speaking, we have prosecutors, defense attorneys, correctional authorities, and officials from the judiciary. But also, we have a lot of private citizens here who are passionate and knowledgeable about this issue on both sides of the issue. My job is to present a neutral, nonpartisan overview on what is a especially fraught subject, and I will do that to the best of my ability. I don't have any partisan positions on these issues. I'm not choosing sides. If I misspeak somehow about the law or phrase something in a way that somehow doesn't appear to be neutral enough, I apologize in advance. It's certainly not my intent to do that. So with that, I'll begin. So first, both the federal and state and local governments have the power to regulate firearms, and they do this. So there's overlapping authority between these laws here. And in terms of federal and state overlap, this is similar to, say, controlled substance laws. The federal government has enacted a regulatory framework for the lawful manufacture, sale, and possession of firearms at the national level. This includes licensing and detailing the roles of firearms dealers, manufacturers, and importers, addressing the interstate transporting of firearms, and the taxation and registration of certain firearms, including particularly dangerous weapons such as machine guns, short barrel rifles, and shotgun and silencers. The federal government also prohibits certain categories of persons from possessing, receiving, and shipping and transporting firearms. However, the federal government is one of limited powers, and any federal law must be enacted pursuant to one of those enumerated powers in the Constitution. Congress has no general criminal law or police power authority, except for, say, the District of Columbia, but in general, they don't have that. So when regulating firearms, Congress has to look to one of its other enumerated powers. And historically, in the firearms area law, they've used either their taxing authority, their spending authority, or more significantly, their Commerce Clause power, which is fairly broad. But Congress will always need to look to a jurisdictional hook in order to legislate in this area. Now, states, though, across America do have broad police powers to enact criminal and regulatory laws that focus on public safety and health. And this power was retained through the 10th Amendment's Reserve Clause and the principles of federalism. In Minnesota, the state legislature has, for the most part, preempted the ability of local units of government in Minnesota to enact substantive firearms-related laws. So basically, nearly all the laws on firearms in Minnesota are via the legislature. They're state laws enacted by the folks like you. Now, speaking of preemption, for the most part, Congress has not attempted to preempt the law of firearms laws. So therefore, there's this continuing dual jurisdiction at the state level and the federal level. However, a state cannot enact a law that directly conflicts with the lawfully enacted federal law, and that's the Supremacy Clause. The federal law would trump the state law in that case. So all of this gives a good deal of leeway for both the federal government and the state of Minnesota to regulate firearms. However, this leeway is not unlimited. There are a few constitutional principles that would limit this, and most notably, the Second Amendment. The Second Amendment was part of the original of the Bill of Rights. It was adopted in 1791. However, over the course of history, there hasn't been a great deal of clarity on the scope of the Second Amendment, and there hasn't been much guidance from the United States Supreme Court on this. This changed dramatically in 2008 with the United States Supreme Court's Heller decision. Now, a detailed description of the Second Amendment and its related case law is well beyond the scope of this overview. But I've been asked to at least touch on it. So the Heller decision, the Supreme Court, at its core, held that there is an individual right for law-abiding citizens to keep and bear arms for lawful purposes, particularly for self-defense in one's home. So it put to rest discussions of whether the Second Amendment protected a collective right to bear arms through militias or if it was an individual right, holding that it was the latter. So it's a very significant case. However, in many respects, it was a limited decision. It didn't really purport to define the full scope of the Second Amendment's protections. It didn't address the scope of the right to keep and bear arms outside of one's home. In fact, it stated that, like most rights, the rights secured by the Second Amendment are not unlimited, and then it went on to suggest that many longstanding gun control measures would not be affected by it. Also, Heller did not provide a test or standards for future courts to use when deciding Second Amendment cases. Now, 2 years later in the McDonald case, the U.S. Supreme Court once again took up the Second Amendment, in this case holding that in addition to applying to the federal government's regulation of firearms, the Second Amendment also applied to those regulations of state and local governments. So it incorporated the Second Amendment through the 14th Amendment applying to states. So therefore, we know that the Minnesota legislature is bound by the Second Amendment. It serves to protect the rights of Minnesotans to keep and bear arms. However, as I said, the full scope of the Second Amendment protections are not completely settled. Now, Heller and McDonald spawned thousands of challenges to gun control laws across the United States. These cases have played out and will continue to play out in the upcoming years. Notably, the United States Supreme Court had basically refused to, for the most part, weigh in again on the Second Amendment post-Heller, post-McDonald. However, this changed recently as well. There's a case pending before the Supreme Court now, New York State Rifle and Pistol Association versus New York City. That's a Second Amendment challenge, but there's also a couple other challenges in there to a New York City law relating to firearms. The Supreme Court accepted this case, and oral arguments were heard earlier this month. Now, this is the first real Second Amendment case accepted by the United States Supreme Court in nearly a decade, and it has the potential to significantly alter the Second Amendment landscape, especially considering that the court's makeup has shifted since the Heller and McDonald decisions. However, there's a pretty good chance that the court may not address the actual underlying merits of the law, and that's because of what's called a mootness issue. The underlying law at issue has been changed, and because of that, it's possible that the Supreme Court might not get to the merits. In fact, the news reports of the oral argument indicated that justices' questions seem to be focusing quite a bit on mootness. In either event, there'll be a decision later this spring. So now we're going to talk about kind of the nuts and bolts of the presentation. First, we'll concentrate on ineligibility to possess firearms. Both federal and state law address this issue. Minnesota incorporates essentially all of the categories of federally ineligible persons and also contains a number of Minnesota-only disqualifiers. Now, for the categories where Minnesota and federal law both disqualify a class of person from possessing, remember that these are separate, independent disqualifiers. The person may be charged and punished under either federal law or state law for these disqualifiers. Now, nearly all of the Minnesota disqualifiers are in section 624.713. That section is in your packets. On the top right, it says number 1 circled. I will be referring to this statute quite a bit over the next 20 minutes or so, especially subdivision 1, which lists most of the ineligible persons, and I'll be referring to specific clauses within that. But I will be jumping around a bit just to keep related concepts together. Now, in general, in Minnesota, it's a gross misdemeanor for a prohibited person or an ineligible person to possess a firearm in violation of these provisions. There are a couple exceptions I'll point out as I go. Now, a violation of the federal disqualifiers, again, which we have as well, is a felony under federal law. It's a 10-year felony. Also, unless otherwise indicated, these disqualifiers that I'll mention apply to all firearms, not just certain types. So first, we'll focus on criminal conviction-related disqualifiers, with the exception, that I won't be talking about domestic assault or abuse offenses for now. We'll do them separately. So the first clause I want to point out is Clause 2. It has to do with crimes of violence. This clause, ineligibility provision applies to persons convicted and adjudicated delinquent, so it includes minors as well, and includes similar crimes in other states. The term crime of violence is a defined term, and if you, also in your packets, there's the definitional section 624.712. The top hand right says number 2. So we'll be referring to that as well. If you look there, subdivision 5, which is circled, is the crimes of violence definition. Now, these are all felony cases, and as you might imagine, these are what are presumably some of the worst of the worst crimes, homicides, felony assaults, violent rapes, things like that. However, there are also a few other crimes there, such as simple robbery, some of the nonviolent age-based criminal sexual conduct cases, such as the so-called Romeo and Juliet offense, the offenses involving positions of authority with K-12 officials having relations with underage students, and also any felony violation of Chapter 152, which is the controlled substance chapter of law. Now, a person who commits a crime of violence and is ineligible and who then possesses is guilty of a 15-year felony. So this is an example where the gross misdemeanor fallback does not apply. The person would also face a 5-year mandatory minimum prison term under Section 609.11. However, a judge on her own motion or that of the prosecutor may sentence without regard to the mandatory minimum if there are substantial and compelling reasons to do so. But the judge can't do this if the offender has previously been convicted of a violent offense committed with a dangerous weapon. Now, this ban for crimes of violence is a lifetime ban on possessing firearms. However, a person is authorized to petition a court under 609.165, and the court may restore the person's right to possess a firearm for good cause shown, as long as the person is no longer incarcerated. Now, Clause 7 of 624.713, Subdivision 1, also addresses crimes of violence. However, this is a smaller provision. It addresses only persons placed in pretrial diversion programs for crimes of violence, and the prohibition there lasts until the program is completed and the charge is dismissed. I'm going to skip now to Clause 10, small Roman numeral 1, which addresses felonies. This provision applies to a person convicted, so not adjudicated delinquent here, but convicted of any felony in any court. However, it doesn't apply to certain commercial type offenses such as antitrust or restraint of trade crimes. This disability or disqualification applies until one of a number of things happens. Either the person is pardoned, the offense is expunged, or it's somehow set aside, or the person's civil rights have been restored. And that's, in Minnesota, that's the most common way that that you'll get your rights back here. In Minnesota, you'd get your civil rights restored for a felony offense basically on completion of the sentence. It happens automatically. That would include any incarceration time, but also any community correctional supervision like supervised release or probation. This applies to any firearm. Next, I'll talk about Subdivision 1A of 624.713. This applies to persons currently charged with a felony. So if you're charged with a felony, you can't receive, ship, or transport a pistol or a SAMSA. So it's a more limited prohibition. Now, I use the term SAMSA. That is defined in Minnesota law in the definitional section 624.712, the handout number 2, clause 7. You could look at it. I know the reason I use that term is because it's a defined term in Minnesota law. SAMSA stands for semi-automatic military-style assault weapon. So I use that term because it's specifically defined in law. I know there are some people who prefer other terms for SAMSAs, but I use the defined term. This subdivision 1A prohibition on persons charged with felonies, however, you might have noticed it doesn't apply to persons who possess firearms. So if you can continue to possess a firearm, a pistol or SAMSA in this case, until you're convicted. But you can't receive a new one or ship or transport a pistol or SAMSA. And I'll point out that both of these prohibitions are also federal disqualifiers as well. However, the federal law applies to all firearms. It's not just limited to pistol or SAMSA as one half of Minnesota's is, so to speak. Clause 11 addresses certain gross misdemeanor offenses. A person who's convicted, and now I'm referring again to 624.713 subdivision 1. A person convicted of a listed gross misdemeanor will have a 3-year ban on being able to possess a firearm. And during that time, the person cannot be convicted of another offense. Now, you could read the list of those crimes. It includes such crimes as harassment, stalking, bias assaults, crimes committed for the benefit of a gang, child neglect and child endangerment. It also includes similar crimes in other jurisdictions. Clause 4 has a 3-year ban on persons who are convicted in Minnesota or elsewhere for misdemeanor or gross misdemeanor Chapter 152 violations. Chapter 152, again, being the controlled substance chapter of law. And during that time, you can't have been convicted of any similar felony, any similar conviction within the 3 years. Now, the reason it doesn't address felony violations of Chapter 152, as you may remember, that's already defined as a crime of violence, and it would result in a lifetime ban. Moving on then, next we'll look at chemical dependency related prohibitions. Clause 4 also addresses this. It applies to a person who is or who has ever been committed by a judicial determination for treatment for the habitual use of a controlled substance or marijuana, unless the person is restored under a specified process in Minnesota law, which is in subdivision 4 of 624.713. Now, you might want to linger at the language there. This type of language is repeated a couple of other times. For example, mental health disability. It's a fairly high standard. A person essentially has to be civilly committed. It's basically an involuntary civil commitment. So there's a certain process that has to be followed before you would be disqualified under this. Clause 10, small Roman numeral 3, makes a person who is an unlawful user of any controlled substance ineligible to possess. Now, this is you can contrast this with Clause 4. This is really, there's no specific process or procedural protections listed under this. This clause is also a federal disqualifier. And this is a little bit out of sequence, but I'll point out here that all of the Clause 10 prohibitions come from federal law. They were incorporated a long, long time ago into Minnesota law, and therefore they work as those dual disqualifiers that I talked about. Now, the decision to include these in Minnesota law, in some respects, at least from my point of view, seems to have created a few redundancies, most notably later on with the mental health prohibition. It's basically repeated in 2 separate clauses within the same subdivision. However, and also, of course, there's some redundancy in the sense that they're also federal disqualifiers, but that makes sense because, you know, you can be charged with a federal crime there. And also, I'll just point out just that some of the wording of the disqualifiers in federal law, while they're quite similar in many cases, identical to the Minnesota disqualifiers. In some cases, there's slightly different wording, which could have a substantive impact. Before I move on here, I'll point out that the main federal disqualifiers are in Chapter 18 of the United States Code, Section 922, Paragraph G. And I'll point out there that that specifies that those disqualifiers there apply to shipping, transporting in interstate or federal or foreign commerce, or possessing in or affecting commerce, or receiving firearms which have been shipped or transported in interstate or foreign commerce. The reason I read that is to illustrate the whole jurisdictional hook there. That's where the federal government, that's where Congress is essentially implicating its Commerce Clause authority to legislate in that area. Clause 5 now, going back to 624, 713 sub 1, provides that a person who has been committed to a treatment facility in Minnesota or elsewhere by a judicial determination that the person is here chemically dependent is ineligible to possess a firearm. This ineligibility lasts until the person has completed treatment or the disability has been removed via the specified process in subdivision 4 of 624.713. Clause 6 addresses, it's a slightly lower standard. It applies only to peace officers, but implies to peace officers informally admitted to a treatment facility for chemical dependency unless the officer has a certificate from the facility head discharging the peace officer from the facility. Next, we'll talk about age. This will go back to Clause 1. This provision provides that a person has to be at least 18 years of age in Minnesota to possess a pistol or a SAMSA. So this is only related to those type of weapons. There are 4 listed exceptions there. We won't get into that. A violation here is a 5-year felony, so it's not your standard gross misdemeanor here. This only applies to the pistols and SAMSAs. In other areas of Minnesota law, there's essentially a 16-year-old minimum age for possessing firearms other than pistols and SAMSAs, with exceptions there, including parental consent. And actually, that applies for the pistol SAMSA one as well. Federal law, on the other hand, provides an 18-year-old minimum age to possess a pistol, with certain exceptions, and there's no federal minimum age to possess other firearms. Clause 10 is, as I mentioned earlier, the Minnesota incorporation of federal disqualifiers. You can read through these. I've already mentioned a couple. I'll mention a few others later when we talk about domestic assault and abuse and mental health, but I'll point out 3 so we don't leave them out. Small Roman numeral 2 applies to fugitives from justice. Small Roman numeral 5 is aliens illegally or unlawfully in the United States. And small Roman numeral 6 are individuals discharged from the United States Armed Forces under dishonorable conditions. And again, these are federal as well as state prohibitions. There are, in addition to these mandatory disqualifiers, Minnesota law does authorize judges in certain situations involving pretrial releases to order that a person not possess a firearm. This can happen during a pretrial release decision regarding a domestic abuse-related charge, which is a defined term in the statute, or a crime against the person, which is also defined in the statute. In that case, a judge can prohibit the accused from possessing a firearm or other dangerous weapon while on release. Those 2 sections are 629.715 and 629.72. Also, even where there's not a specific requirement that a person can't possess, or even where it's specifically authorized that a judge can order that, I would think that a judge, when sentencing a person, for example, a convicted person to probation, or when ordering conditions of release, even if it's not actually listed there as an authority to do it, I think they can do it anyway, just under their general rules, general law. Now I'm going to talk about mental illness, individuals who are ineligible based on mental illness. This is another area where both federal law and state law prohibits this. The Minnesota prohibitions are in Clause 3 of 624.713 Subdivision 1 and Clause 10, small Roman numeral 4. Again, this is an area where there's some redundancy there. These prohibitions are, I would think, quite substantially similar to the federal prohibition. The federal prohibition is worded differently, appears to be a little bit broader, but it's fairly similar. Now, under Minnesota law, a person who is or who has ever been in Minnesota or elsewhere committed by a judicial determination that the person is mentally ill, developmentally disabled, or mentally ill and dangerous, those are defined terms, to a treatment facility, or a person who has ever been found incompetent to stand trial or not guilty by reason of mental illness, those individuals are ineligible to possess under Minnesota law. And again, basically under federal law as well. Now note that these are specifically statutorily defined individuals. There's a specified judicial process that makes them ineligible. Anything below this standard, which is a relatively high standard, doesn't result in automatic ineligibility. Now, there are many common situations that this would apply to. So here are a couple common situations where you would not be prohibited under Minnesota law automatically from possessing. Very common: seeing a therapist, taking mental health-related medications, having an undiagnosed mental illness, including a potentially severe one, having a diagnosed mental illness, even a particularly severe one. And also, similarly, a person who has been subject to a so-called 72-hour hold is not automatically ineligible either. The chair asks I linger here for a second to talk a little bit about that. A 72-hour emergency hold is a statutorily authorized hold whereby either a peace officer or a health officer, which is a defined term that includes specified mental health professionals, can take a person into custody on their own authority and transport the person to a treatment facility. This can also be initiated in a few other manners too. There's some parallel provisions. But basically there needs to be signs of mental illness and that the person is a danger to self or others, if not immediately detained. Now, the facility head must approve of the detention once the person gets there. And the hold, as you might, based on the title, the hold is for no more than 72 hours, excluding weekends and holidays. Now, this all occurs essentially without judicial involvement. There's no hearing that precedes this. It's a temporary, short emergency hold to protect the person and others. So while there's due process involved to merit the hold, there's not the same type of due process, say, that would merit a actual civil commitment where you would get an automatic loss of your firearm rights. Now, a person who does, in fact, lose their eligibility to possess a firearm due to civil commitment as mentally ill, developmentally disabled, or mentally ill and dangerous, or via being found incompetent to stand trial or not guilty by reason of mental illness, is prohibited until and unless the person gets until the person gets the specified judicial relief via the process in Subdivision 4 of 624.13, which is a judicial process. Now, there's more on all of this in the memo that's in your packets, and it's posted on the internet, including some more information on federal law and the restoration process into both federal law and Minnesota law. I'm going to continue then and focus now on domestic violence and domestic abuse. And this is an area where the chair asked that we kind of take a step back and talk a little bit about some of the concepts that we're going to talk about here. So we'll give some basic information about domestic violence in Minnesota. So as you all know, for a long time, Minnesota has addressed domestic violence, attempted to address it as its own independent, specific evil, and done so in a host of ways. The legislature has created pathways for victims to seek proactive protection against future domestic abuse by abusers, and also created specific separate crimes related to domestic violence with their own enhancers, other consequences and procedures specifically related to domestic violence. Now, relevant to this presentation, Minnesota created a standalone crime of domestic assault. It's codified at 609.2242. And the penalty can range from a misdemeanor to a gross misdemeanor to a felony, depending on the number of priors. Now, for the most part, domestic assault is very similar to fifth-degree assault, which is the general crime of lower-level assault. And that makes sense because that's essentially where it came from, where it was carved out from. I'll point out that, however, it gets complicated because a domestic assault can be charged as other types of crimes, including, say, first, second, or third-degree assault, depending on things like the harm caused or whether a weapon was used at the time of the offense. There are also related crimes that could be at play here, but which aren't limited to actual domestic violence situations. They're more generally worded, so harassment, stalking, for example, threats of violence, which we used to call terroristic threats. In addition to the after-the-fact crimes, a victim of domestic violence can seek proactive protection via a domestic abuse order for protection. So order for protection, OFP, you've heard about that for years, of course. That's under 518B.01. Now, an OFP is a situation where a victim of domestic abuse can petition a court for relief from the perpetrator of the domestic abuse. The statute is a bit of a hybrid between a civil and a criminal statute. It's a civil statute, it's a civil proceeding. However, the underlying conduct of domestic abuse is often criminal. However, there's no prerequisite that a crime be charged or the person be convicted. And a violation of an OFP, even though it's a civil order, is a crime. Now, domestic abuse is defined pretty broadly. And if you look, there's a handout, top right, handout number 3. It's the definitional section from the Domestic Abuse Act. Subdivision 2, paragraph A defines domestic abuse, and it means physical harm, bodily injury or assault, the infliction of fear of imminent physical harm, bodily injury or assault, or terroristic threats, criminal sexual conduct, or interference with an emergency call if it's committed by a family or household member against a family or household member. So that begs the question of what is a family or household member? That's addressed in paragraph B. It includes spouses, former spouses, parents and children, persons related by blood, persons who are presently residing together or who have resided together in the past, persons who have a child in common, regardless of whether they have been married or lived together at any time, a man or woman if the woman is pregnant and the man is alleged to be the father, regardless of whether they've ever been married or lived together. And then finally, persons involved in a significant romantic or sexual relationship. Now, both of those definitions are important not only for what we're about to talk about, but also because they're cross-referenced a number of times in other laws relating to this. So, under the OFP law, a victim of domestic abuse will petition the court alleging domestic abuse by a family or household member. The other party will be given notice, and after a hearing, the court can order specified relief. The relief that can be ordered is quite broad. It includes things like ordering the abusing party to stop the abuse, imposing location requirements, no contact between the parties, and then but also more specific and far-reaching remedies as well. Generally speaking, an OFP is in effect for 2 years, although it could be longer, and it can be extended. A court can also order, under emergency situation, an ex parte OFP without notice to the abuser and without a hearing if there's an immediate and present danger of domestic abuse. However, this is a more limited remedy than the full-blown OFP in terms of what can be ordered. Now, a violation of an OFP is generally a misdemeanor. However, a violation within 10 years of a prior domestic abuse-related crime, a defined term, would be a gross misdemeanor. And then a third offense within 10 years would be a felony, or an OFP violation committed with a dangerous weapon is a felony right off the bat. Minnesota has a similar type of proactive relief provision called a harassment restraining order. This is issued under 609.748. This is an HRO as compared to the OFP that we've been talking about. There's at least 3 main differences for purposes of this discussion. First off, there's no required relationship between the parties. They don't have to be domestic abuse, domestic related. They don't have to be family or household members. So it could be your neighbor, it could be a stranger. The remedies are more limited for the court to order. And then probably most importantly here, there's no direct impact on the harasser's ability to possess a firearm. Virtue of either being subject to the order or, generally speaking, for violating it. Minnesota also has what's called a DENCO. That is issued under 629.75. That's a domestic abuse no contact order, or DENCO. A DENCO can be issued in a criminal domestic abuse type situation. It could be issued as either a pretrial order or as a post-conviction probationary order. It serves as a separate parallel order to any other pre- or post-conviction order relating to the proceeding. It's limited in scope. It applies to no contact between the parties. Penalties range from a misdemeanor to a gross misdemeanor to a felony, similar to the OFP and HRO. And similar to the HRO, there's no specific effect on firearm possession by the issuance or violation of a DENCO. However, it's possible that the parallel order that a judge might order in the actual criminal proceeding could include one of those restrictions. Now we'll talk about actual ineligibility based on domestic abuse and domestic violence. First, we'll talk about conviction-related ineligibility. A person who is convicted of a domestic assault, 609.2242, or fifth-degree assault when the fifth degree involves a family or household member. So it's where the fifth degree is essentially a domestic assault, but for some reason it's charged or convicted under that. So those two cases, or the case where you get convicted of harassment or stalking under 609.749. Now here I'm talking about the crime of harassment or stalking, not the HRO. So the crime of harassment or stalking, or a violation, a conviction for a violation of a domestic abuse OFP. So again, domestic assault essentially, harassment, stalking, or domestic abuse OFP. A conviction for any of those will result in a 3-year ban on the person from possessing a firearm. Now, it's not quite that simple in the sense that an OFP violation only applies to pistols in that situation, not all firearms. So they're not 100% consistent there. And during this 3-year ban, you can't be convicted of any similar offense. Now, if a firearm is actually used for the crime, two things happen. First, the firearm gets summarily forfeited. And second, the judge can impose a ban, a longer ban, anywhere from 3 years is already applied. So it could be longer than 3 years, up to the lifetime of the person. And this would apply to any firearm, including an OFP violation. There's a similar disability that relates to non-domestic assault fifth-degree convictions that I'll mention here because it doesn't quite fit anywhere else. If you get convicted of a fifth-degree assault where it's not a domestic violence situation, and if it occurs within 3 years of a prior, so it's your second in 3 years, this would result in the offender getting a 3-year ban on possessing a pistol. Any of these people who are ineligible under what I've just said, who violate the ban, would be guilty of a gross misdemeanor. And again, remember that this isn't as neat as it might be, in the sense that circumstances, number of priors, use of a dangerous weapon, as I said, could change the actual underlying charge or the conviction and result in a different disability period. So, for example, if you get convicted of a felony, as we said, you're going to get a ban until your civil rights restored. If it happens to be a crime of violence, you'll have a lifetime ban. So it's going to depend sometimes on how it actually gets convicted. Now we're going to talk a little bit about OFPs again. This time we're the simple issuance of an OFP. Certain domestic abuse OFPs, and here again we're talking a subset of these OFPs, and I'll call the subset qualifying OFPs. A qualifying OFP based on the issuance of it, not a conviction, there's no prerequisite conviction or anything, would result in the abusing party losing their right to possess a firearm while the order is in effect. So what is a qualifying OFP? A qualifying OFP is an OFP that restrains the abusing party from harassing, stalking, or threatening the petitioner, or restrains the abusing party from engaging in other conduct that would place the petitioner in reasonable fear of bodily injury. And also, the OFP has to include a finding that the abusing party represents a credible threat to the physical safety of the petitioner, or prohibits the abusing party from using, attempting to use, or threatening to use physical force against the petitioner. This only applies to OFPs where there's been notice and an actual hearing. It doesn't apply to ex parte OFPs. Now, the federal government has basically this exact same prohibition. In fact, that's where Minnesota got it from. I think it was 2014. So again, it's a separate, independent, parallel federal disqualifier there as well. Minnesota also has a similar concept to this that applies to qualifying domestic child abuse orders. I won't go into detail there. I'll just at least point out that we do have that. There's another concept that I want to talk about, which is started out as a federal disqualifier that Minnesota wound up cross-referencing a few years ago. So it's also Minnesota as well, but it came from the federal, from Congress. Under federal law, a person convicted of a misdemeanor crime of domestic violence, so a misdemeanor crime of domestic violence conviction, that's a defined term under federal law. It basically means any state, federal, or tribal crime that has use or attempted use of physical force or threatened use of a dangerous weapon. If there's sufficient specified due process for the offender, and it has to be within the federal concept of what essentially is family or household member. The feds have a different definition there, and it's a little bit more narrow than the Minnesota definition. But in that case, you would get prohibited from possessing. In some respects, the federal misdemeanor crime of domestic violence is both broader than the Minnesota concept of domestic assault and also kind of narrower at the same time. This is you may remember, this is the Lautenberg Amendment from 1996. The important thing about this, though, is the federal law basically the disability applies until you get, say, pardoned, expunged, or set aside, or you get your civil rights back. The issue with this here is that since it's a misdemeanor, under Minnesota law, if you commit a misdemeanor, you don't lose your civil rights. So really, there's no way to get your civil rights restored. So for the most part, this is essentially a lifetime prohibition when it applies to states like Minnesota. And again, this is a concept that Minnesota has specifically cross-referenced, so it's a federal and a state disability. There are the only other thing to talk about here then is Minnesota has specific mandatory transfer language in law, too, for certain classes of ineligible persons when they become ineligible. This applies to three groups of individuals. Individuals who are ineligible under Minnesota law based on a domestic assault conviction or a harassment stalking conviction, or based on the issuance of a qualified OFP, as we've discussed, and also a qualifying domestic child abuse order. Upon the issuance or upon that ineligibility, the person has to transfer all the person's firearms. In that case, the person who's ineligible has 3 business days to transfer all firearms to either a federal dealer, to a law enforcement agency, or to a third party who may lawfully possess the firearm, but who doesn't live in the same household as the offender. This can be a temporary or a permanent transfer. However, it's a lifetime ban. It essentially has to be a lifetime transfer. The person who is ineligible, who is transferring the firearms, is required to file a specified proof of transfer with the court. Now, if the court determines that it's an emergency situation where there's an imminent risk of causing substantial bodily harm to another person, the court is then required to order law enforcement to take immediate possession of all the person's firearms. Now, there's a lot more detail in the law than that, but that's essentially the overview of it. I'll point out too here that it's a crime for the person who receives the firearm, so the person it gets transferred to, it's a gross misdemeanor under 624.7144 if the person who accepted the transferred firearm, if the prohibited party essentially gets the firearm back while they're still prohibited. I'm going to continue then. The next issue is transfers of firearms, including background checks. When it comes, and this is another area where federal and state law both address this, I think the easiest way to understand this in some respects is there are kind of three relevant questions when it comes to transfers in terms of what the applicable process or laws will be. First is a federal dealer involved? And when I refer to federal dealers, sometimes I'll refer to an FFL, that's a federal firearms licensee. So is a federal dealer involved? What type of firearm is involved? Is it a pistol, a SAM-SAW, a shotgun? That'll affect the requirements. And then finally, is it entirely an intra-state matter, or is it somehow involve another state? So first we'll talk about federal dealers. Federal law requires a person who wishes to engage in the selling of firearms to obtain a federal license. A federal licensee must comply with applicable federal and state laws when acquiring and disposing of firearms. These laws include but aren't limited to specified record-keeping requirements, reporting requirements, and ensuring that any kind of required background check on the transferee is conducted. A federal dealer will be licensed to operate from a fixed location, but they're not required to conduct business out of a commercial premises. And they also may temporarily conduct business from other locations within the state, such as a gun show. Now, regardless of where a transfer takes place, if the federal dealer is the one doing the transfer, a federal dealer must always comply with applicable law, including background checks, even at gun shows. Under federal law, it's unlawful for any person other than a licensed dealer to, quote, engage in the business, unquote, of dealing in firearms. Now, that's a defined term under federal law. It's, there's no real clear, objective, bright line rule as to when you fall within that definition. There's no, if you sell X number of firearms within X number of days or receive a certain amount of money total for firearms. It's more of a case-by-case determination based on the totality of the circumstances, although obviously factors like how many firearms you sell is quite relevant. So if you go to a bricks and mortar type business like a Cabela's or something like that, selling firearms, clearly they have to be licensed. It gets a lot more murkier when there's an individual involved who's selling firearms, when that person kind of gets to the level where they have to be licensed. So when a federal dealer transfers a firearm to a private citizen, to a non-dealer, and I'm talking any firearm here, it doesn't matter what type of firearm. It does in a sense because antiques don't count in this respect. But if a federal dealer is transferring a handgun, a shotgun, basically they have to do a number of things. First, they have to require the transferee to provide identification, and also to complete an application, a federal application called a Form 4473, which is going to give identifying information about the person and have the person answer a series of questions relating to their eligibility to possess a firearm. And then the dealer has to require the transferee to submit to and pass a point-of-sale background check using the FBI's NICS system. And then also, of course, things like keeping records of the sale and all that required under federal law. Now, Minnesota has an additional, what I call a Minnesota add-on here. This is a Minnesota requirement that it only applies to federal dealers, and it only applies to federal dealers when they're selling or transferring a pistol or a SAM-SAW. In this case, either of three things essentially has to happen. Either the transferee has to show a valid Minnesota transferee permit, which is also known as a permit to purchase. That's free. The person would apply to local law enforcement for that. They would do a Minnesota background check, and assuming the person is eligible, the person would get the permit. It'd be, again, valid for a year and for an unlimited number of purchases during that year. The other alternative is to require the person to show a permit to carry under Minnesota law. Of course, the permit to carry has a different purpose, so it's a little more complicated. It's good for 5 years. You have to pay a fee for it. You have to have training in the safe use of a firearm. But either of those permits require a recent Minnesota background check conducted by Minnesota law enforcement. If you don't have either of those, then what you have to do, the only other alternative, is for the parties to submit what's called a transfer report to local law enforcement. That would prompt a background check. It would delay the sale up to 5 business days while local law enforcement perform a background check. So essentially, those are the 3 options there. My understanding is that the transfer report isn't used that often because it would be more inconvenient and would delay the sale. However, of course, the other 2 permits are something you would have to have in advance when you go into a federal dealer. Next, I'm going to talk a little bit about private parties, non-dealers. First, we'll talk about intrastate transfers between private parties. So here's where, obviously, everything, say, takes place within Minnesota. There's no Minnesota or federal law requirement that a background check be done or records be kept or anything be reported for transfers between private entities, private parties, when they reside in Minnesota and the transfer occurs in Minnesota. Federal law and Minnesota law essentially just doesn't regulate entirely intrastate transfers between non-dealers. Now, that assumes that they're not prohibited parties, that it's not a prohibited firearm, it's not a prohibited location, things like that. Minnesota does have an incentive for a private transferor, though, to essentially get a background check. There's potential criminal liability for a private party who transfers a pistol or a SAMSA, so just those 2, to another party without essentially employing that Minnesota add-on I described. So if the private seller doesn't require either the permit to carry or the permit to purchase or filing a transfer report, then if the transferee uses the firearm within a year to commit a felony crime of violence, and either it was reasonably foreseeable that the transferee would do that, or the transferee was actually ineligible at the transfer. If that occurs, it would be a gross misdemeanor. Again, unless you avail yourself of that other process I described. Next, I'll talk about non-intrastate transfers between private parties. The general rule here is that you can't have this is federal law basically, you can't have a direct sale of a firearm between private parties who reside in different states. However, you can have a transfer there, it's just not a direct transfer. Basically what has to happen there is the parties have to run the actual transfer through a federal dealer. Now, the rules are going to be different depending on whether a pistol or a non-pistol is involved. But again, you would have to run it through a dealer, which would prompt the record keeping and the background check at the dealer. There's no specific Minnesota or federal law when it comes to gun show sales or transactions or internet or online transfers. Basically what that means is the normal or general rules are going to apply. So again, you ask yourself the 3 questions: is a dealer involved, what type of firearm is involved, and is it entirely an intrastate matter? One practical complication I would think of an online sale, though, would be the actual delivery of the firearm if the parties don't actually meet in person to transfer it, which leads us to a short discussion on shipping firearms. A private party can ship a firearm to another private party within the same state, or to a dealer in any state. But, and that would, I think the easiest way to think about that is like shipping, say, through a common carrier like FedEx or UPS, assuming they'll take it. When it comes to actually mailing a firearm, the rules are slightly different. A private party can't mail a handgun, but can mail other types of firearms. Again, yeah. A private party, though, can't ship directly a firearm to another private party in another state, just within your state. So you'd have to go through a dealer in that case. Now, there's a memo in your packets on background checks and transfers. It has a little more information on what the test is for dealers being engaged in the business, and also there's more specific information on the background checks themselves. So, example, like what a NICS background check under federal law would require. So the last topic we'll discuss is crimes related to firearms. So Minnesota, as you would imagine, has a host of crimes relating to firearms, as does federal law, but we won't cover federal law. I'll just mention a few general categories before we focus more on the transfer-related firearms. So there are numerous situations, of course, where an existing crime's penalty might be enhanced because of either use or possession of a firearm by the offender during the course of the crime. This might include harassment, stalking, second-degree assault, criminal sexual conduct cases. Also, Minnesota has a mandatory minimum prison sentence. We mentioned that earlier related to crimes of violence. But certain crimes committed with a firearm would result under 609.11 in a mandatory prison sentence. We also have a number of crimes that are based on the specific type of firearm involved, such as machine guns, short-barreled shotguns, silencers. Minnesota also has a number of location-based prohibitions or crimes related to firearms. The most notable might be just public. You can't generally carry a firearm in public. If you carry a pistol, for example, without a permit, it's a gross misdemeanor, permit to carry. We also have prohibitions and penalties for K-12 schools, possession there, correctional facilities, state hospitals, treatment facilities, Capitol complex buildings, and courthouses. Again, these are kind of beyond the scope of this presentation, or at least based on what the chair asked. We also have crimes relating to specific actions relating to firearms. So, for example, using, pointing, brandishing, discharging, endangering a child with firearms. Obviously, those are crimes. But this leads us to crimes directly related to transferring firearms, which I'll go into in a little bit more detail. First off, we have a straw purchase crime. This is 624.7133. It's a gross misdemeanor for a person to purchase or otherwise obtain a firearm on behalf of or for transfer to a person who's known to be ineligible under federal or state law. It's also under 624.7141. It's a gross misdemeanor for any person to intentionally transfer a pistol or a SAMSA, knowing that the transferee is basically ineligible. That becomes a felony if the transferee uses it within a year in furtherance of a felony crime of violence. Section 624.7132 has a number of penalties ranging from a misdemeanor to a felony that apply to federal dealers when they transfer a pistol or a SAMSA in certain circumstances. So, for example, if they transfer a pistol or a SAMSA in violation of the Minnesota add-on law, in other words, requiring the transferee have a permit to purchase or carry or filing a transfer report, or without getting specified information that's required in a Minnesota statute from a transferee, or if they transfer to a transferee who has made false statements during the process, or if they transfer to a person who's under the age of 18. We also have very similar penalties that apply to the transferee in those situations as well, and also a penalty for a transferee who doesn't provide required ID under Minnesota law. 624.7131 makes it a gross misdemeanor to make a false statement to obtain a transferee report, aka a permit to purchase. And then similarly, 624.714 makes it a gross misdemeanor to give any false information, material information, when applying for a permit to carry. And then finally, 609.66, which in general is kind of a hodgepodge of crimes related to firearms and dangerous weapons, but there are a couple of relevant crimes there I'll point out. It's a crime to recklessly furnish a person, any person, with a dangerous weapon in conscious disregard of a known substantial risk that will be used in furtherance of a felony crime of violence. It's also a crime under that statute to furnish a person who's under 18 with a firearm within the municipality, or it's also a crime to furnish a child who's under 14 with a firearm outside of a municipality. Mr. Chair and members, that's all I have. So I guess if you have any questions, and actually, if members also have questions that are a little maybe beyond the scope of this or I can't answer right away, obviously we can talk offline and try to get you the answers. I have a lot of information with me, but sometimes it's hard to actually locate the specific information in this setting. So thank you.
Mr. Backus, you said that's all you had, and I couldn't help but notice the relief on the faces of everyone behind you.
Mr. Chair, the relief is all mine.
Well, Mr. Backus, I'd invite you to come back to our panel seat, and then we can open up our discussion. So who would like to start it off? If you have, Senator Hall.
Thank you, Mr. Chair. And thank you, Mr. Backus, for all the information, especially what was in our packets. Senator Limmer, thanks for pulling this together. It's going to give us a lot of information I think we needed because we are seeing an increase in crime in Minnesota. Mr. Backus at one point stated that our state does have a mandatory minimum sentence for certain firearm offenses. And as I looked, it was section 60911. But as I was reading the Sentencing Guideline Commission's reports, and I think, members, I think we have those two that I'm going to refer to in your packet. What my question ended up being is, what is our criminal justice partners who have been charged with the enforcement of laws that we, the legislature, has given them and passed, what are they thinking? As I look back, if I can refer you to the 60911, let's see, the one that's dated 11/22 with the Sentencing Guidelines Commission. And let me make note that as I read through these, it's not a Ramsey County, even though they're referred to a lot here, and it's not a Twin Cities problem, Senator Limmer. I think this problem of violence is a statewide problem. So the document I'm referring to, 11/22/19, shows history data of the mandatory minimum sentencing for firearms crimes. And to me, this is staggering. If you look at the graph on figure 1, page 5 of 11.
Pardon me, Senator Hall. Members, this is the report that Senator Hall, and if you look at the bottom of the page, there's a date, 11/22/19. That's the report that you're referring to, Senator Hall.
Thank you, Senator Limmer.
Sorry to interrupt you.
Nope. So
These are also available to the public too, and we'll show you how to pull that up on internet, or we might have copies in the back. Senator Hall.
Thank you, Mr. Chair. So looking at the figure 1 graphic, it shows the date line from when we set in minimum sentencing requirements, and 1999, and they started out at about 30%. When I say they, I'm talking about the judicial system. About 30%, shall we say, over the first 10 years or so, were waived. The mandatory minimum sentences were waived. The last 10 years have really been bumped up to about 40%. And so one of my questions is this what we initially as a legislature expected when we set these requirements in, that the mandatory minimum would be waived 30% of the time, and now in the last 10 years, 40% of the time? That concerns me. So again, it shows that prosecutors and judges have refused to use the tools that we've given them involving crimes of firearms. What are the prosecutors and judges thinking? 40% of the time across the state? That's my question, and that's a serious question. So I think if we also look at the other document we received from Sentencing Guidelines Commission, the report on 1017, there's a graph on page 5 again. It's called Table 4. And it shows that the prosecutors waived the minimum 608 times, and judges waived the minimum 814 times. Again, why is that happening? What are they thinking? Have we put out our thoughts on this that, you know, to me, 10, 20% might be okay, but we're talking 30 and now 40% of the crimes that are out there that are felony and firearm cases with mandatory minimums are being waived. So, Senator Limmer, that's one of my questions, at least initially here. In the earlier sections of 1017, 2019 document, we have information about how often prosecutors objected to sentencing departures, and judges ignored these objections. And again, it's crimes of violence. That's disturbing to me. So I would like further information to understand what is even happening in our criminal justice system with the current laws we have. So at a minimum, though it appears we have a much larger systemic problem, our criminal justice system apparently is sending a message to criminals in our state that we are not serious about felony level crimes involving firearms. So many of the articles today before us, I keep seeing guns used in many of the crimes committed were illegal. And Mr. Backus talked about the ineligible. So illegal carrying, meaning a person who commits a crime with it was supposed to not have it in the first place. It was illegal for them to have it. Mr. Backus again went over that, Mr. Chair. I'd like to explore, if we could, as we move forward, about the penalties and whether the county attorney and judges are opposing those penalties when a person has a firearm and when they are not allowed to have a firearm. Now, maybe members and Senator Limmer, maybe we have pretty decent laws on the books that are not being enforced. I don't know, but the information before me here and before us is disturbing. So I'd like to hear further information, if we could, from law enforcement and probation officers about what they do when they come across guns or other dangerous weapons in the hands of ineligible people or people on probation, that they can give us some real life, real-time perspectives of what they're seeing out there and how we are going about handling current laws on the books, because we certainly do have an uptick, if we want to call it that, in violent crime. And thank you for highlighting that today, Senator Limmer.
Thank you, Senator Hall. I guess the question would be, what part of mandatory don't you understand when it comes to prosecutors and judges?
Exactly.
I know there are complications to law, but nevertheless, 40% seems awfully high. And it's something that we should look into, and we will this coming session, and see if we can get some answers on that. The people that you would like to ask those questions, as you know, are not here, but we'll make sure they get an invitation to come before us. Anyone else wish to make discussion? Senator Johnson?
Well, thank you, Mr. Chair. And thank you, Mr. Backus, for the information this morning. I don't know who called this a window dressing of a meeting, but that was very informative. And I learned something in the hour and a half as we were going through the laws that are currently on the books. One of the concerns that I really have, especially this year, and especially in the city of St. Paul, is we see a homicide rate that's nearly doubled last year's. In 1 year, almost doubled our homicide rate here. In a recent news article by the Pioneer Press, and I think it was November 7th, there was an interesting quote in there where, I'll just quote them, and it says, "The common denominator found predominantly across all homicides is guns in the hands of the wrong people, using them to settle disputes over gang issues and narcotics." So in here, they're talking a little bit about the interplay between illicit drugs, gang violence, and these are some issues that we really need to talk about. There's young people on the streets right now that their outlet has become violence, and it's, as Dan was talking about, it's a trend that we've got to be looking at. We've got to be concerned about what's going on in the streets of our community. In a couple of months, I'm going to bring in my wife and 3 kids down here, and I tell you right now that my wife is not real excited about it, looking at the headlines in the news. And I'm sure people living in this community are concerned about that exact same thing. One of the other things that I'm really concerned about now is that here in town, Police Chief Axtell has asked for, from Mayor Carter, some resources, some things that will point out where shooters are located in a quicker fashion so response can be much better, much quicker, a safer community. There was a violence prevention grant that the county attorney was going after, but backed off of that when he realized that he didn't get support from the current mayor. How are we supporting our law enforcement? The people that are going out there, the people that are risking their lives to go out and protect us in this community, I think our community leaders really need to be addressing that. I think we need that support for our law enforcement, for the laws that are currently on the books. How are we enforcing those? I think we really need to take a look at that. It's a cycle that is problematic to me, and it should be problematic to the folks out here. With that, I mean, the points are made, but I think we really need to look at how are we supporting our law enforcement, how are we enforcing our laws. Just like Senator Hall said, what are we doing with our laws that we are enforcing them and really making them applicable. So that's all I had, Mr. Chair.
Any further discussion? Senator Anderson, or is someone over here? Senator Pappas.
Thank you, Mr. Chairman. I did have a question. I don't know if it can be answered right now, and that has to do with shipping gun parts. That how do the laws apply to shipping gun parts where you can build your own weapon? I don't know if Mr. Marcus knows. And do those only have to be done on the internet? I think people can do that, but do they have to come from dealers?
It looks like Senator Backus is anxious to answer that question.
Yeah, Mr. Chair and Senator Pappas, I don't have a definitive answer of that right now. I believe that's addressed. I'd have to go through my notes. I know often that parts of firearms are included within the definition, but I don't want to answer definitively in case I misspeak. But I can look into that and get back to you.
Senator Pappas, I have tried to study this myself. There are some parts, let's say a scope on a rifle, that isn't necessarily a part of the rifle. It's a bolt-on addition or a magazine that could be purchased. Even a
Mr.
grip.
Chairman, I'm talking about assembling an entire weapon, like an assault weapon.
I'm getting to that. The firing mechanism is usually in the frame of the gun. It's where the trigger is. And I know that one can purchase, let's say for a rifle, one could buy that. I believe that the firing mechanism has to be sold through an FFL, Federal Firearm Dealer. But we'll check into that. I would like to know more definitively more about that myself. So we'll put it on our list of things to look up. Any further discussion? Senator Anderson.
Thank you, Mr. Chair. Thank you, Mr. Backus, for, I couldn't write fast enough all the things I might want a copy of what you've given to me, or given us today, because there's a lot. But I'm very interested in the issue of domestic violence. The reason I look at that, after looking at this homicide report that you gave us in our packets, and the fact that there are many people here in the audience and in the state, for that matter, that are very much concerned about domestic violence. I, for one, have had that experience as far as in my family. My sister, who, because of work experiences, had to move their family from St. Paul to Wisconsin. He was a railroad engineer, and he had gone to court while in St. Paul for drinking problems, alcoholic related. And he signed himself in to Alcoholics Anonymous and was able to hopefully stay on the straight and narrow. But when he moved from the St. Paul area to, because of a mandatory thing by the railroad, he fell off the wagon and started drinking again. And one night, and this came to me secondhand because it was through my sister and family. One night he came home and he pulled out a loaded .45 and pointed it at my sister and her 4 children. And this was like at 1 o'clock in the morning, and played games, pulling the mechanism back on the gun, and basically making demands. And finally at 5:30, somewhere in there, he got tired and decided to go back to bed, or what he came home for to begin with, but because his wife was up waiting for him, he decided that enough was enough. But fortunately, he put down the gun, put it back in the holster and put it away. But my sister decided, after 18 years of marriage, that this was enough abuse. And so she had to go into hiding to basically be, hopefully, free from any more threats to not only her, but to her 4 kids. And so when I see this report that comes out here on different homicides, and the fact that husbands and wives and individuals have used the mechanism of firearms to go after one another, and we see in the report that over a 30-year period in 2018, ending in 2018, at least 685 men and women and children have died from documented domestic abuse in all kinds of ways. At least 14 Minnesotans were killed due to violence in domestic situations. The intimate partner themselves, with 4 by strangulation and 3 by gunshot and 2 by stabbing, and the others were family, friends, and bystanders. But most of them were women, and I think of my sister in this situation. And I'm glad she's still with us. At least 20%, according to this report, of the 2018 perpetrators who killed the victim with a firearm were prohibited from possessing at the time of the murder. They weren't supposed to have it. Now, my brother-in-law, he was a hunter, fisherman. He had no crime of violence whatsoever in his life, but I think the alcohol took over, and it caused him to be in a situation. But he fled the state, and that's unfortunate. It also says in this report that 55% of the 2018 cases, the perpetrator had a documented history of domestic violence, and they were documented with police and court records. And as Mr. Backus has given us today, both state and federal laws prevent domestic abusers from possessing a firearm. Again, I say, both state and federal laws prevent domestic abusers from possessing a firearm. Back in 2014, we've updated our laws. We've adjudicated for domestic abuse backgrounds from people who are abusers from getting hands on their guns, and yet the number of cases and the number of incidents continue to grow. And what's interesting in this packet that was passed out to us is that our current laws on domestic abusers are not being enforced. There's a report in here on page 63 from CARE 11 from February 2018 that says these statistics they found were very much being ignored as far as the enforcement part. So when we look back on all the different years, as already mentioned by Senator Hall, we're seeing more and more and more of what's happening in our law enforcement, our justice system. We've passed these laws, we've updated our laws, and it seems like, what's going on? Who is supposed to be enforcing these laws? Who are supposed to be doing it? Is it the judges? Is it our county attorneys? Is it law enforcement themselves? Is it the prosecutors? Or is it the probation officers? These statistics, I don't think have changed much in 18 from going back. And yet, if the laws we as the legislature have passed are not being enforced by those who are charged with law enforcement details, part of the law and order system, how can we protect those, such as my sister and others, who are constantly in danger or have been violated through domestic abuse? So that's a question that needs to be answered, I believe, and I think Senator Hall brought that up, and so did other senators. Thank you.
Thank you, Senator Anderson. Senator Latz.
Thank you, Mr. Chairman and members. First, I want to note I'm glad that we have the attention of this committee to these issues. They are important issues for us to understand. I will also note that we have a thick packet before us today, which some members have cited, but which just appeared, at least from our side, in our members' packets this morning. We did not have any advance copies, no opportunity to read through them in anticipation of making questions, or asking questions, and making comments at this hearing today, and we were paying attention to Mr. Backus, so not reading through them during that either. I do have a number of questions, but I first want to respond to Senator Anderson. I too am grateful that your sister is here, and you know, the fact is, no amount of laws that we put on the books are going to be fail-safe in every circumstance, and often the laws that we put on the books rely on individuals to report concerns or questions or violations before authorities can get involved in any way. And I don't know the individual circumstances, I'm not asking for them, but it's quite common in domestic abuse situations that the victims of domestic abuse tell no one or almost no one about the home situation until it's too late or almost too late. So another very common thread through all of these discussions, through all the crimes we're talking about, and I would guess, I haven't seen the statistics, maybe they're in the materials we have here, I don't know. I'm going to guess 80% or more of the criminal activities that we're talking about involve, in one way or another, alcohol or drugs, substance use or sale, and probably use more than anything else. And until we as a society get a handle on addressing those concerns, I don't think we're ever going to make meaningful progress in reducing the overall crime rate. You go into the state prisons, you go into the county jails, and you're going to find that most of the people there have alcohol or other substance use or abuse problems, need treatment. They need treatment. I will also note that our local jails and our state prisons are probably the largest institutions that contain persons with mental illness. Now, I want to hasten to add that only about 4% of those people that have mental illness are violent in any way. So it's a very narrow subset. And we should not simply say, let's address mental illness and we're going to solve all these problems. But those that our system is inadequately set up and resourced to address the people who do have mental illness that have shown some violent tendencies. One thing that I don't know is whether or not Senator Anderson's sister reported previous incidents to law enforcement. I'm using that only as an example because it's a common thread throughout all these incidents. Whether a criminal case was brought, whether there had been prior criminal cases brought, whether there was ever a law enforcement contact in the past with with her ex-husband, whether a 72-hour hold had been an option or tried. And I've got some questions that will illustrate why I think that's an inadequate remedy, but that's another option that could have been tried. What we do know is that absent, certain circumstances, there's no red flag law in place, and law enforcement might not have had authority, certainly in many instances running up to this last case, this last instance, to separate the person from the firearms. Simply, they could have taken him, put him on a 72-hour hold, and there still would have been no legal authority, if I understand Mr. Backus's presentation correctly, to confiscate the guns. They would have been sitting there waiting in the household for him to return at the end of the 72 hours unless he's subsequently committed, or sooner than the 72 hours, because ultimately it's the facility's decision whether or not the criteria for holding the person remain valid. But I have, I guess, a number of questions. Maybe I'll just kind of tick through them for Mr. Backus or one sort of question I want to ask is what authority under existing law does law enforcement have to remove firearms from a person that's in crisis?
Mr. Backus?
Mr. Chair and members, as far as I know, unless it relates specifically to a situation where perhaps you're arresting the person or taking the person into custody, I'm not really aware of legal authority for law enforcement to do that. I mean, I assume as a practical matter, when you're taking someone into custody, so to speak, for a 72-hour hold, I would imagine they would, to protect themselves and the person, disarm the person if the person's armed. But again, absent, well, unless there's some kind of court order maybe related to the proceeding, if, certainly if the judge, if the person is charged with offense, if it gets down to that level, then it might be different. But in terms of just an encounter, I think it would, go down to just basic law of when, law enforcement, taking a person into custody can certainly pat down the person and everything to protect themselves. But I think beyond that, I'm not really aware of authority.
So
Senator Latz.
Mr. Chairman, Mr. Backus, if a person is in crisis, they're not necessarily committing a crime, but there's a fair amount of evidence that they are likely to be a danger to themselves, either suicidal or to others in their family or neighbors or others in the community. They could be personally taken into a healthcare facility for a 72-hour hold, subject to that facility's further determination. But there would be no authority under existing law for law enforcement to gather the firearms that are in that person's home, so that when the person returns home, there's nothing there at the home for them to use as a gun. Is that my understanding?
Mr. Backus?
Mr. Chair and members, yes, that's my understanding, again, absent what we've discussed.
And I understand there are some law
Senator Latz.
enforcement agencies, Mr. Chairman, thank you, that will actually take some of the firearms under those circumstances into their possession. But as soon as the owner of the firearms goes to the police department and says, I want my guns back, the police department really doesn't have any authority to refuse, do they?
Mr. Backus?
Mr. Chair, again, not to my knowledge, no. Perhaps at some point, maybe we could certainly ask law enforcement, how they might deal with that practically speaking, but I'm not aware of a process for them to follow in that situation.
Senator Ladd.
Mr. Chairman, Mr. Backus, if I understood you correctly, a person who is brought into a healthcare facility on a 72-hour hold, the initial determination of whether or not they are a threat to themselves or others is made by the law enforcement officer that is bringing them in. But a facility could go through an evaluation when they are received at the hospital or wherever it is, could make a determination within the first hour that the law enforcement officer was erroneous, or that the immediate crisis has already passed, or within 24 hours or 48 hours, couldn't they? And then they simply release the person. Is that, unless there's some other court order that gets involved, but without some other court order, they could just release the person. Is that right?
Mr. Backus.
Mr. Chair and members, yes, I mean, the continued hold, my understanding is it has to be pursuant to the direction of the actual facility head. So yeah, it's possible that the person can definitely be released before 72 hours if they deem that appropriate. Also, a person has a right to essentially petition a court for release before 72 hours as well. I don't know how common that is, but that is part of the law as well.
And then,
Senator Latz.
thank you, Mr. Chairman. Mr. Backus, somewhere in that point, if a facility determines that there is a more long-term, substantial, ongoing crisis, the procedure at that point would be to seek a petition in court for some kind of a longer-term mental health commitment. Would that be correct?
Mr. Backus.
Mr. Chair and Senator Latch, yes, that's correct. I mean, basically at that point, the determination would be made that perhaps a formal civil commitment would be appropriate. And in that case, basically, my understanding is that a judge would have the authority in that situation, if they're going to petition for civil commitment, to order essentially a continued hold beyond that, pursuant to the civil commitment.
Mr. Chairman, Mr. Backus, from the order for protection proceedings, an ex parte order can be issued by a judge upon a petition from a person who fears for their own danger. My understanding is no one else can bring that petition. And then the judge could issue it if there's I think you used the term immediate and present danger. Was that right?
Mr. Backus.
Mr. Chair and Senator Latz, yes, the statute, it's 518B.01 subdivision 7 ex parte order. It's where an application under the OFP law alleges an immediate and present danger of domestic abuse.
And then so, Mr. Chairman, Mr. Backus, in that case, a court could order that a person have no contact with the protected party without there being a formal hearing in court, without there being any evidence, without the opportunity of the person subject to the order to tell the judge on his or her own behalf why the ex parte application is not accurate. So basically, they just go in and the judge can issue the order, and it's a no contact order, and that could include, firearms prohibitions in that order for protection?
Mr. Backus.
Mr. Chair and members, no, not to my knowledge. It would have, in that situation, would have to be essentially a normal OFP, not an ex parte. So you would have to have a hearing. There would have to be notice for a person's firearms rights to be addressed in that situation, at least specifically in terms of what the statute authorizes. And then it would have to be, as I called, essentially a qualifying OFP, so just certain types of OFPs.
Okay, so Mr. Chairman,
Senator Latz.
I got a couple questions within that category. First of all, I guess, is the point that a judge can order deprivation of an important right of a person without having a hearing first. That is, they could order a person to stay away from their own residence and have no contact with the family member, in the case of an order for protection, spouse, child, parent, without having any hearing first. Is that correct, Mr. Backus?
Mr. Chairman,
Backus.
Senator Latch, yes.
And then if the subject of that order requested a hearing, which they do have a right to do, how quickly must the court conduct that hearing? Or how soon must they conduct that hearing?
Mr. Backus.
Mr. Chair, members, I'm sorry, I'm going to have to page through the statute to answer that question.
Mr. Chairman, I think it's about 14 days or something to that effect. And then they would get a full evidentiary hearing. But and this is considered constitutional and adequate due process to bar someone from their own home or from certain places of work if the protected party seeks to be protected in their workplace, and to be barred from seeing their own children. This is considered constitutional and adequate due process. A post-deprivation hearing within however many days it is. And I don't want to override Mr. Backus as he's reading through the statute, but basically the same principle applies for harassment restraining orders that are issued ex parte as well when you're talking about non-family members. Isn't that right, Mr. Backus?
Mr. Backus.
Mr. Chair, members, again, I have to catch up with that. I'd have to catch up with that.
But the basic principle of the issuance of an ex parte, I'm sorry, Mr. Chairman, the basic principle of an ex parte order being issued without an evidentiary hearing, without the right of the subject person to testify or present evidence on his or her own behalf, court based only on a petition or allegations by a person seeking protection. That applies in the harassment restraining order context for non-family members, just as it does in the order for protection context for family members, right?
Mr. Chair and Senator Latch, yes, that's correct.
And so, Mr. Chairman, that is considered constitutionally sufficient due process for purposes of depriving a person of their right to see, make contact with, and go to certain places unless and until they seek a hearing somewhere down the road. And an ex parte order can be in effect in either of these cases for up to 2 years, as I understand it. Actually, I think in the order for protection context for up to 50 years under certain circumstances. Now, my understanding also, and I guess I'm kind of forcing Mr. Backus here to research and listen at the same time. I'm not sure that's entirely fair, but when we get to that subset of orders for protection, where there are certain criteria in the order that says, you know, a person is a certain kind of a risk, they pose an immediate threat, that kind of a thing. Then you get to those orders where firearm possession is not allowed. Is that right, Mr. Backus?
Mr. Backus.
Yes, Mr. Chair and Senator Latz, yeah, in terms of simply the issuance of the OFP, it would be, again, that subset of persons who are subject to it, not all OFPs necessarily.
Mr. Chairman, for what it's worth, in my experience, those criteria are included in the forms that judges review when they fill out to issue OFPs and HROs, and it's pretty standard, I think, to check those boxes. But if those criteria don't apply, then a person, actually, they'd have an advantage if they wanted to possess their firearms and those weren't part of the ex parte order. They could simply not request a hearing on the issuance of the OFP or HRO, and they would not be subject to any firearms restrictions. Is that right, Mr. Backus?
Mr. Backus?
Yes, Mr. Chair and Senator Latz, the firearms restriction under the OFP law is only after, it doesn't apply to ex parte.
Senator Latz, my question back to you, and maybe you know this being an attorney. Do judges use this range of activity to seize guns during OFPs or any other restraining orders? It seems like, at least in the prosecution of criminal law, where we have written mandatory direction to the courts in the use of a gun, 40% of the records aren't being, 40% of the cases are not taking the guns in the first place. And so I'm wondering if that pattern is the same when judges are considering restraining orders.
Mr. Chairman, I think you're conflating two questions here. I think the 40%, the 30% to 40% figure that Senator Hall was referring to applied to the waiver of the mandatory minimum jail sentence or prison sentence at the end of a criminal process when there are convictions. I think it's a separate question whether or not judges are checking off the boxes on the ex parte OFPs or HROs that would have the effect of prohibiting firearm possession. And then the follow-up question to that is what is being done to remove the firearms from the possession of the person who's the subject of the HRO or the OFP. And this is an area of concern. It's a concern that was brought to my attention last year. We raised it in committee. And we had conversations with the courts about getting the word out to judges. Wisconsin has some judges that are taking some further steps to try to enforce these firearm turn-in orders. But it's one of those orders where, you know, sometimes a judge will issue an order for a person to turn in a firearm, but then the follow-up question is, how is that enforced? Typically, if a court issues an order, there are two parties to an order, and the party that isn't that is objecting that the order is not being followed will bring a motion before the judge telling the other person, asking for the order to make the other person enforce it. This is a little bit different because right now under current law we are expecting in some cases law enforcement already to affirmatively go in and collect firearms. The order is typically for the person to turn in the firearms, though not for law enforcement to go get them. And I don't know if we have any statistics available.
Senator
on how
Johnson
often that
wanted to weigh
happens.
in on this subject. Senator Johnson.
Thank you, Mr. Chairman. And Senator Latz, the only issue that I've got with that is that underneath the enumerated powers of the U.S. Constitution, in the Bill of Rights, we've got an enumerated protection right there that says that we are entitled to firearms, and there are some restrictions to that. But where in that, you know, we've got, you're talking about HROs and things like that, and I don't see the same constitutional weight put in on those as we do on a firearm. So are we conflating two different issues here on that? It seems to be that we're muddying the waters a little bit.
Well, Mr. Chairman, Senator Johnson, there is a separate Second Amendment, of course, that addresses firearms possession. But as Justice Scalia wrote in the Heller decision, all constitutional rights are subject to some regulation and restriction. I personally would say that the question of firearm possession in the context or deprivation of rights to see your family, see your children, is a pretty substantial imposition on a person's freedom. I would say more of an imposition than the ability to hang on to a pistol that's in a gun case in someone's home. So, you know, how you want to weigh those two, you know, I guess depends on the perspective you bring. Maybe some people would feel that the right to possess their firearm is more important than their ability to see their family or their children. But we've already crossed the constitutional threshold with regard to, you know, personal freedoms to associate with others. in the OFP and the HRO context. Although Mr. Backus has clarified for me, even the ex parte HRO, there's no condition under which you can order the firearms, or firearms can be restricted. I hope I've sort of addressed. I don't think we're conflating two issues. There's certainly a question to be had, and whether it's a fair comparison. I think it's more than a fair comparison.
Mr. Chair. I'll leave it with that.
No, I do have a few other additional questions, Mr. Chairman, if you'll allow me. Thank you. I guess I already addressed one of the questions that was raised having to do with the mandatory transfer of firearms in the event of, say, a conviction for a domestic abuse or a domestic assault. If the court issues the firearm turn-in order, how does that get enforced? That's a legitimate concern. And part of the problem is a resource problem, is one may expect the judge to follow that up, but then every judge is going to be having their staff following up on every domestic assault conviction to try to verify whether or not the person has turned in their firearms or turned in the affidavit saying they don't have any within the 72 hours or so that's required. And quite honestly, our judicial system, our judges don't have enough clerks to be able to monitor that for every court order that they issue. So that's a resource issue in part, and part a procedural issue. The question arose with regard to transfers of firearms, and I guess I just wanted to make sure I clarify there is nothing in existing law that requires a background screen for private party to private party transfers within the state of Minnesota, so intrastate, of pistols or semi-automatic military-style assault weapons or long guns. Is that correct, Mr. Backus?
Mr. Backus.
Mr. Chair and Senator Less, that's correct.
And some percentage, I think people will argue over the numbers here, the numbers I've seen are up to 40% of all transactions between private parties in Minnesota occur outside of the federally licensed dealer system where a background check does occur. And it's not really a question for Mr. Backus. I'm not expecting him to know.
Sir, what's the source of that 40% number?
Everytown USA did calls to a variety of locations, attempts to make purchases, and that was their researched result. I understand there's some other information out there. The number may not be as high as 40%. Part of the difficulty that we have is that there is a prohibition in Minnesota on doing research on gun violence by state agencies anyway, so it's hard for us to get some more objective, one might argue, data on that because it would violate state law to use resources to gather that data, which is a little bit crazy, if you ask me, why we would want to willfully deprive ourselves of valid evidence so we can make good public policy decisions. But I think that's also perhaps one of the bills that we will consider at the next hearing. There is a bill by Senator Klein to address that question.
One of the figures I heard was it was as low as 3% for private transfer or sale. So I don't even know where that source came from. Perhaps it's hearsay, or perhaps it's validated by some figure, but we can dig into it.
Mr. Chairman, I've heard the same number from your majority leader. I've heard the Washington Post recently publish some numbers. Haven't read the article. I don't know the source that suggested 15%, but that came to me by way of hearsay. So I think it'd be valid information for us, but whatever the exact number is, there's some percentage, I think some substantial and for me, unacceptable percentage of transactions that occur without any screening, even to determine if the buyer is eligible under current law to purchase or possess a firearm. And if we allowed that kind of slippage in our airport security, I think a lot of us would be very uncomfortable getting onto an airplane
That's if we did that.
If we did that. So we have a remedy that's proposed to that, to try to close that number down substantially. That's the expansion of criminal background checks that is my bill, and I hope we have an opportunity to hear that in January.
You will.
Thank you, Mr. Chairman. Mr. Chairman, I guess I've already addressed a little bit the mandatory minimum question and the 30 to 40%. There's a lot of data that is not concluded in the sentencing guidelines information that we have presented to us here. But I think to understand that more thoroughly, we would really have to understand, whether or not there was any initial criminal charge, or what the initial criminal charges were, whether the charge of the violation of that particular possession statute was count 1, typically considered to be the most serious of the charges, or count 2 or 3 or 4 in a series of criminal charges. Quite often, in plea negotiations or agreements to plead to a more serious charge, if there are certain sentencing agreements, including presumably waiver of mandatory minimums. It is not judges ignoring the statutes when they don't sentence to mandatory minimums. So it's not a question of what part of mandatory don't you understand. As Mr. Backus stated, there is a specific provision in existing statute that allows judges to make findings that under statute authorize the waiver of that mandatory minimum sentence. And what we don't have in this data, is even my cursory review of it, is what were the circumstances under which a judge made a determination that those mandatory minimums would have been an unfair outcome in that particular case. The more that we impose mandatory minimum sentences by statute, the less discretion we give to judges to fashion a just or fair outcome in our system of justice. And you need to have I think you need to have that kind of flexibility. We also don't know what the circumstances are relating to alcohol or drug use in connection with the crime that was involved, whether there was brandishing or other use of the firearm in the commission of the offense as opposed to possession, what kind of possession it was it on their person, was it in their bedroom, was it in the other side of the house that they owned, was it in the trunk of their car, was it in the trunk of a car that had 3 passengers and they couldn't figure out who it belonged to. So there is a presumption that it's owned by the owner or the driver of the vehicle. We don't have all of that kind of information, which I presume judges will take into consideration in deciding how to sentence a case. So I think we need to have more information to make those kinds of decisions. We also don't know how difficult it would be for prosecutors in any particular cases to prove the counts that are charged. And we don't know if it's charged in a complaint that involves more of an accessory to a crime or an aiding and abetting element in the complaint, or whether it's not the aiding and abetting provision that brings in the criminal defendant to face potential sentencing consequences for that kind of a provision. So simply citing numbers like this is very difficult to say, well, we've got a crisis out there in judges failing to follow the law. I think you got to know a lot more about the circumstances before you can judge in an individual case whether it was a fair or a just outcome. We also don't know whether there was a self-defense component to the situation either. And quite often, if a defendant asserts self-defense, it's the prosecutor's burden to prove it wasn't self-defense. So there may have been substantial proof issues involved, or there may have really been a self-defense there, but a defendant didn't want to take the risk of going to a jury trial and facing 20 years in prison if they're convicted, even though they honestly and truly believed, and maybe someone somewhere objectively understood that they were defending themselves, but they were the ones that were facing the criminal charges, not someone else, or maybe as a co-defendant in a case. So a lot of circumstances to factor in.
Mr. Chairman, my comment is related to this issue, this waiver issue.
Pappas.
If you don't mind me throwing something in. Senator Latz said a lot of what I wanted to say, but I think what would be really useful is if we look at recidivism rates, between people who are sentenced to prison and people who are sentenced to probation. And do they offend again? And then, of course, that saves us a lot of money if we're not sending people to prison. But also, I'm reminded of our visit we took to the Veterans Court, Senator Limmer and Senator Anderson and myself, and how their extremely high success rate they had when they used not just one strategy, but probation, treatment, drug test, accepted responsibility, showed remorse, accountability, back in court every 2 to 4 weeks, and the caring team that really wanted them to succeed. And that was an amazing, Senator Hall, you would have loved it. That was an amazing model for us to look at, because I know how caring Senator Hall is about people. So, thank you.
Mr. Chair,
Yes.
this kind of I think is a good lead-in to something that Senator Latz referred to earlier, and that's the mental health issues. And all of this relates, because most of the people that are incarcerated have chemical dependency or mental health issues. And one of the things that I think we need to focus on in a broader view, excuse me, forgive me, I have a frog in my throat, that we need to be getting upstream of the issue on mental health. And that one of the things that we're finding, and I think some of the materials do include some stories about mental health crisis centers and approaches to mental health, which you kind of alluded to. But what we're doing now is looking at very closely the idea that if we can take and not have someone put into the justice system and rather put them into a treatment system, and there are many mechanisms for doing that. In my own community, our police officers are now starting what's called a co-responder program, where when there is a call involving behavioral health, they will actually take a licensed master's level psychologist or other mental health professional with them on the call. The object being the police officers receive the call, and that's where a lot of these calls come in. They're emergency calls. The police officers will observe the situation, see if it's stable. If it is, or if they can stabilize it, that mental health professional will then, on the scene, make an assessment. This is important for several reasons. First of all, if the assessment is that there's a mental illness component, in many cases, they will be able to divert that person into a treatment program without having to take them into the justice system. This kind of then plays into the other backside of it, where we do have these special treatment courts and where we do try and get people into treatment, to get the help that they need. So I think this is something we need to focus on, that the mental health crisis that we have is closely related to the problem of crime and violence, and that we can address much of it by diversion rather than incarceration when it's appropriate. I think that one of the things that this ties into very, very importantly is that in many cases where there is a problem with someone who does have a mental health issue, and there's a question of a potential suicide or potential harm to others, that family members get involved. In fact, in the packet, there's a story about the Washington County program where they have a 24/7 hotline now working, and a mother called in, and her child was apparently suicidal. They were able to send out a mental health professional and were able to deal with that issue without ever having to reach a confrontational stage. So there are many ways that we can approach this. And this program in Washington County, I think, is one. The one that is being used in my community in St. Cloud is patterned after a Colorado program where they actually do embed mental health professionals with law enforcement. And they're keeping statistics on that, and we're waiting for reports that will show just exactly how effective it is. But at first blush, a couple of things are happening. First of all, it's reducing the number of incidents where police are required to take violent action because someone is literally having a bad hair day and not able to really deal with it, whereas a mental health professional would be able to help them out. The second thing I think that we need to remember is that there's another component to this mental health issue, and that is the officers themselves that are having to face these issues, that are out in the field protecting people, and they're being subjected to significant trauma, especially when they're involving gang violence and other types of violent activity. One of the things that was found in the Colorado study is that having that mental health professional along when something did happen, it was invaluable to the police officers that were involved because the mental health professional saw what happened and was able to relate to them and work with them. Sort of an unintended benefit that seems to have shown up from this. So I think, without getting too deep in the weeds, I'd like to stay at pretty high level here. We do have to address the mental health issues. Our legislature in the past couple of years has started to try and look at the issue of when we closed the regional treatment centers, we did not have a backup plan. And so many people who actually do need day-to-day or at least weekly intervention are not able to receive that. We're using the prisons to replace those mental health centers. So 3 years ago, we did start with some funding for bricks and mortar. St. Cloud Hospital in my district is one of the ones that is getting a grant to create a mental health crisis center to add beds so that we don't have to warehouse people in emergency rooms for 2 or 3 weeks. That's happening right now. But those people that are being diverted, that are put on the 72-hour hold rather than sent to jail, if they receive that treatment early, and they talk to a mental health professional early on in the encounter, the outcomes are much, much better than if we try and deal with it after we incarcerate and put them in prison. So I think that this is important, an important component. The legislature this year did include some money now to help start staffing some of these crisis centers. And so I'm hopeful that this will allow us to get upstream of a lot of this gang violence, a lot of this just street violence that is centered around mental health and chemical dependency, because in many cases the two are tied together. And so and I'm glad that Senator Latz brought up that mental health component, because I think it's very important that we look at that as it relates not only to gun violence, but all kinds of violence. And I think will provide us another set of tools in the toolbox to start dealing with reducing this violence that's taking place. I think it's kind of rhetorical, but we need to do things to support family activity and help people who have these problems in the families and the mental illness issues that they face. And simply some caring approaches. I know there's a program here in, I believe in Minneapolis, in the Somali community. It's pizza and tea. And volunteers basically go out in the street in the Somali community and talk to young people. Simply say, come on, have some pizza and here's some tea, let's sit and talk. And even if it's only for a couple of minutes. They're doing this voluntarily. This is not a government program. They're out there. But we need to support that sort of thing, because that's how we get at this, the backside, is to try to find ways to engage young people so that they're not looking to use weapons to settle their disputes, so that they do understand that someone does care. And so I think as we go further in this inquiry, it's important that we not forget that private component, and we not forget the mental health issue that we're dealing with, and the problems that we're having in this state dealing with mental health, and getting people to feel comfortable with saying, yes, there's a problem here, and the problem is we need to help that person who is experiencing those mental health issues. Thank you, Mr. Chair.
Thank you, Senator Ralph. Is there any further discussion? Senator Latz?
Thank you, Mr. Chairman, and I appreciate what Senator Ralph has said, and what it points out is there are substantial lacking resources at all levels of government to do the kinds of things that we need to do to get upstream. You know, whether it's the budget that comes before this committee to fund law enforcement training. You know, we impose continuing education requirements, post-board requirements, but we don't provide for 100% reimbursement for local law enforcement agencies to send their police officers to the training. A lot of the agencies don't have sufficient numbers to be able to trade officers out for a day to meet all the requirements as frequently as we would like. It comes down to local government aid, which helps offset costs that our local law enforcement agencies incur, because that's where most of the local law enforcement budgets come from, is our local governments. It comes down to our decision on how many beds to fund in our state prisons for chemical dependency treatment. And how much do we subvent local governments, counties, and so on to do treatment and to have facilities. It comes down to state funding for our mental health services that occur in our public schools, that occur in our state hospital system, in our own commitment system. It goes to judiciary funding for their specialty courts, and we didn't fund their full request for specialty courts last session, and it comes down, including veterans courts, and I know in Hennepin County, a number of other counties have specific chemical dependency drug courts, if you will, and there are specific DWI courts in Hennepin County, all of which is coming out of the judiciary's budget once the initial federal grants expire. So we're talking about a lot of resources. Probation, the topic came up earlier, where probation officers are relied upon to help keep people from committing new offenses, to make sure they're getting the treatment that they need in the communities and so on, and yet our probation departments come to us every year. All three of these systems come to us asking for funding, and rarely do we give them all the resources that they think they need in order to reduce their own caseloads and provide the kind of oversight that would be helpful for all of these. So, you know, it's very good for us to have these conversations every now and then at the committee table, but if we don't back it up by putting our resources into it, by making the priority decisions to fund these things, then it's just empty talk at this table. And we can't expect people to do more than they have the physical capacity to do in their 8-hour days, or in many cases longer days than that. So I'd certainly welcome the opportunity. We may have some resources available this spring to supplement the resources we appropriated last spring to give our law enforcement and our probation departments and our chemical dependency providers and our youth intervention folks and our early childhood intervention folks and our public schools more of the resources they need to get upstream on these problems. And that's a really good segue to really one other point I wanted to make, because there was some attention singling out St. Paul. And I want to identify a couple of things. First of all, we have what appears right now to be a one-year elevation in gun-related violent crime in St. Paul. We have no idea if this is a trend or if this is a more limited spike. So drawing conclusions from the spike, I think, is a little difficult to do. Secondly, the overall violent crime rate in St. Paul is still very, very low in comparison to other urban centers of similar size. So St. Paul, even with the new numbers, the more recent headline incidents that people across the state read and don't often read the whole article, and certainly the articles don't always give all of the information. It's not really fair to draw the conclusion that it's going to be unsafe to walk down the streets of St. Paul with your family, because it is still very, very safe in comparison to most urban areas in the country. And I would further add that it's pretty rare, pretty isolated that you have innocent bystander deaths from these cases as well. When you're dealing, there have been a few, admittedly, but that happens every year. It doesn't minimize the impact, but that does happen every year. But when you've got dangerous situations where you've got gang-on-gang violence, or you've got drug deals that go bad, the participants in those processes are not wholly innocent themselves, typically. And so I think it's hard to draw broader conclusions about the safety of a community for the general public when you look at those individual numbers. I guess I would add in that regard that despite all these laws that we have here, we still have problems. And it's not only a matter of enforcement. One of the questions is, what laws don't we have? And when we get to that question, what laws don't we have, we are missing meaningful methods for screening people who are not in the background check system right now but want to purchase firearms from a private party. We just have absolutely no law that covers that. We've got a couple of incentives in there for the buyers or the sellers to voluntarily submit to background screening. But we have situations where, many situations, I think, where they simply don't have to go through any screening. There's no required screening. It's all secondary, tertiary incentives that are in there, either punishments for doing it the wrong way, or incentives to do it the right way, but no requirement that they do it the right way in the first place. And that's what our background check bill does. And I just want to clarify one thing. It's not a universal background check. There's some pretty substantial exceptions in there for immediate family members. And it's based on the existing permit-to-purchase system that Mr. Backus already described. So a free application to a local law enforcement agency for issuance of a permit to purchase will generate, if there are no background problems, will get you a permit that lasts for a year with unlimited ability to purchase pistols and SAM-saws. And there's no application in this bill to long guns, hunting rifles, if you will. So it doesn't cover those at all. So you could still sell those over the backyard fence to your friends or neighbors without any restrictions whatsoever. With regard to the red flag bill, that's also my proposal. I know there are other bills out there. One of the chief hang-ups there has been the due process and the argument that there's no due process here. Well, I don't think the argument is whether or not there's no due process. There is more than adequate constitutional due process there. The question of whether or not that is sufficient due process for an individual's decision about whether to support it is I admit, a fair question for us to have conversations about. In that regard, I did follow up with Mr. Backus in my own reading of the statute on Minnesota Statute 518B. .01, which is the order for protection statute. When there is an ex parte order that's issued and the subject of that order requests a hearing, that hearing must be held within 10 days in front of a judge. All right, so they get their full evidentiary hearing within 10 days if they want it. That did raise one additional question, which I'm still not clear on, which is, we already know that if the person subject to the order does not request the hearing in an OFP case, that unless the subset criteria are checked in the ex parte order, they are not subject to any gun restrictions, firearm possession restrictions. But what's the situation if they request the hearing, they go to the hearing, but rather than having the evidentiary hearing, they reach an agreement where they waive the contested hearing and they agree to the issuance of an order for protection with the contact restrictions. But they don't go through the contested hearing with a judge making a decision on the merits of the original application. This happens a lot, where the parties will go to the court and the person will say, look, I want to deny on the record that everything that I'm accused of doing is true. I didn't do any of it. On the other hand, I don't want to go through a hearing. I don't want to take a chance of a hearing, or I don't have any problem with the restrictions because I don't want to see that person anyway, or don't want contact with that person anyway. So we'll just let the order issue, that's fine, but no hearing. Under those circumstances, is there a firearm possession prohibition? I don't know the answer to the question, and I'm not sure if Mr. Backus, who's not normally focused in on OFP civil areas of the law, knows the answer, but perhaps he does.
Mr. Chair, members.
Mr. Backus.
Are you talking, Senator Latz, in like when you have like an ex parte order initially and then you do what you described?
Yes.
I don't know that there's a real clear answer on that. I mean, I do know that under the law, under subdivision 6 of 518B01, which is the relief by court, which is your normal full-blown OFP, it says upon notice and hearing, the court may. And under that would include the potential to prohibit abusing parties from possessing firearms. So, I mean, a literal read of that would say that you would seem to need a hearing for the judge to order that. However, in the case you mentioned, I can't answer that specifically. But it does appear that you would need a hearing to order that. But I think the answer might also be answered in the sense of, you know, in your experience, does the judge, in the fact scenario you have, does the judge ever order in that situation other subdivision 6 remedies? Because if a judge does that, then they would presumably be able to also do the firearm remedy because it's under subdivision 6.
Senator Latz, there's more?
Mr. Chairman, that's exhausted my list of questions that I have noted here, but I appreciate the chairman's and the committee's allowing me to ask those questions. I would like, if I may, to reserve the opportunity to ask for further leave if other things come up. But
Did you see the relief in their faces when you said that?
not as much relief as when Mr. Backus completed his initial presentation, though.
Yeah, we made Mr. Backus earn his money today. Senator Dietzick has been waiting patiently for you to finish, Senator Latz.
Yeah.
So.
Thank you, Mr. Chair. Senator Latz addressed most of what I was going to talk about. I think all of what I was going to talk about. But I will just use this time to thank Mr. Backus. I thought that was a very thorough discussion. It was hard to follow that and follow the material at the same time. So I believe I heard you, Mr. Chair, say that you will be possibly hearing Senator Latz's background check bill at the next hearing. Do you have any more information on that hearing, on what other bills, so we can have a little better idea of what to expect?
Yeah. I'm glad you brought that up. I was going to bring it up anyway, but January 21st will be our next meeting. We'll be discussing violence prevention, and guns will be part of that. Our caucus has been having a number of our committees go out state to have hearings. We intend to do that as well. That location will be in Hibbing, Minnesota. And so, and then keep in mind that we're not voting on it. We're having informational hearing on it, and it will, Senator Latz certainly has some bills that he's authored, and there are other bills also that will be heard at that particular review. So we'll get you a little more detail as we put a little bit more meat to the bone on that. I want to personally thank the members in our committee, or not committee, but the audience that we had today. Thank you for your patience. Greatly appreciate that. I have one comment, and that's regarding gun issues. And gun issues, as you know, is contentious. Oftentimes it's controversial. And the reality of our setting in the legislature is we have divided government. We have one party in control of one chamber, and we have another party in charge of the other. I would suggest that in order to pass anything, we need a wider consensus. So anything out on the edges, I don't think are going to be, it won't become law, but something that we can work on, that we can agree to, will be certainly something we have to promote. So at this point, since there's no other questions by the committee, we stand adjourned. Thank you for your patience.